come to staying out of court, which is what we all want to do. Advanced level disclosure strategies, as you can see. And I think the rule of thumb is if you have to ask the question if it should be disclosed, the answer is probably yes. But I'll let Robert get into that. So without further ado, welcome.
Okay, thank you very much, Jody, and good morning, everybody. Thanks for being here. I was looking at my calendar and trying to figure out the last time I did this for the Santa Clara County Association, and I think it was in like July of last year, and so it's been a while. And you know, the challenge I always have is because I speak about this so prolifically around California. I always assume there's a number of people in the audience that have heard me before, especially if it's a large group. But you know, if you have, it's been about a year, so I don't want to say the same thing over again. I actually have, if I could speak constantly and nobody would want to hear me this long, I have about between 30 and 35 hours of non-repeating information on this one topic of disclosure, all PowerPoint based, but nobody wants to hear me that long. So I'm really good with time. We will not go any farther than 12 noon. So anyway, and if you do have any questions as we go along, just put them in the chat room and I'll just kind of glance at it now and then. And I can usually answer most questions. And if they're kind of long or difficult or complex, then I can send you an email. And as I'll mention before we end, if you ever have any question about disclosure, I'm glad to call you. I'm glad to email you. There's absolutely no charge whatsoever. So there's no catch or anything. I'm glad to help. And I do that pretty much every day. You know, I'm responding to things. So I am brought to you by two service providers. Keith is here with Old Republic Home Protection, or you might know as Home Warranty, Staging Risk Management. I don't think their person is here, so I will do a little brief pitch for them, and we'll hear from them in just a few minutes. As last time, I will provide to Jody at the association some seminar notes that have been very substantially improved, or I shouldn't say, well, hopefully improved, but added on to and revised since the last time I was with you. You know, again, I think it was in July. A lot of you know who Gov Hutchison is. He is the absolute grand guru on this topic. And when there's not a pandemic, about once a year, I have the privilege of sharing the podium with him up in the Sacramento area, kind of a large event. Haven't done that for a while because of the whole virus thing. But I will share with you some of the concept I shared with the audience with Gov. My only topic is disclosure of the physical condition of the property. I talk about it more than anybody in the state of California because I've been doing it 31 years. And I can probably answer your questions if you have any, but if I can't, I'll find the answer for you. So here's a kind of a startling statistic. When I first started this 3 decades ago, the number was 45%. So it's like doubled in 3 decades of lawsuits. Now 90% statewide, and this only applies to California, no other state. 90% of the lawsuits are on this particular topic. You know, agents can get sued for lots of things, but this is overwhelmingly the number one source of litigation, and that's where buyers move in and find something that they don't like, that they think was not disclosed, or it might have been disclosed, but not in their opinion, properly so. So anyway, it's a big topic. We'll see what we can do to reduce the chance of those lawsuits. So here's a little review from last time. I'll go through this quickly if you were here about a year ago. You know, here, this is, as you'll recognize, this is part of the TDS, Transfer Disclosure Statement, TDS, or tedious form, if you want to call it that. And it says that we do a visual inspection. So these are like our marching orders for filling out the AVIT. So a question that might develop from this is because of what it says here, is that, does that mean that everything you're going to do in your agents limited visual inspection is really only visual, that you have to be able to like literally see something in order to disclose it. The answer to that is no. Even though, the TDS came out in 1986, so it's been out a long time. That express some of it's changed on the form. This has not changed, visual inspection, but it has changed in the court system. It's kind of, for lack of a better term, morphed, if you will, into being interpreted as any sensory perception. So you don't have to be able to see something to disclose it. If you notice it, however you notice it, and you think the buyers would like to know or should know, we want to disclose it. I like to say that the only buyers who sue, and they're the ones doing all of the suing in this category, um, they only sue when they're caught off guard. It's kind of like a house can be falling apart and in miserable condition, no litigation to come, just as long as the buyers know in advance clearly this place is falling apart, it's in miserable shape. And if they know it in advance, they really have no recourse. So just two quick examples. Everything I do will be brief here because a lot of material to cover. Let's say it could be either side. Let's say I'm the buyer's agent. I go to the property to do my limited visual inspection. I know that some of the COVID restriction things are reducing, but let's just say I'm there by myself, let myself in. It's a 2-story home. I'm upstairs and I have the Avid. And when I mention Avid, the AVID, so I don't have to say it over and over again, whether it's the like hard copy form on your phone, on your laptop, doesn't make any difference. It's all the same, but I'll kind of go with the form in my example. So I'm going into the bedrooms and bathrooms upstairs. And as I traverse the hallway, I get the impression that it's like, there's just a little bit of it's a little off kilter, the hallway. It's a little bit sloped, not a lot, very, very slight, but I have noticed it several times. So I'm done upstairs. I'm ready to go downstairs. And before I do, I look down the hallway and I really cannot visually pick up any kind of a sloping in that hallway upstairs, but I have noticed it. It's a sensory perception, I guess, sense of balance. So I should proceed to disclose it, even though I can't, like, with my eyes, my vision, pick up on it. Something like upstairs hallway floor appears to have some unevenness or something like that. The other example, let's say I'm downstairs and, or let's say I'm just walking into the property for the first time and open the door, there's a very, very strong, like pet odor, you might say. And I happen to know that the sellers have 3 St. Bernards, whatever, living in the house, or 10 cats. And that's kind of what it smells like. So it's not visual. I can't see anything. I might be able to see the pets, but I can't see what I'm smelling. So that would be an example of a non-visual disclosure. Now, how exactly to do that can be a little bit tricky. Let me give you another example, and an example also of an actual disclosure. Let's say I'm in the back of the house and maybe in the family room or whatever, and there's a very overwhelming, pervasive smell of kind of like a musty odor, mildew. Well, a lot of agents would write down there is like a mildew or musty odor in the family room area. The problem is that the word mildew is an adjective. And I like to say that adjectives are the friend of advertising all day long about a house on a flyer, virtual or hard copy, beautiful, wonderful, marvelous, magnificent, scenic, almost no litigation. They're just the enemy of disclosure. So big, small, major, minor, fair, poor, long, short, colors, numbers, whatever, no place in disclosure. And the word mildew in that example, kind of mildew smell in this area, is an adjective. And there's no upside for us to use adjectives, only downsides. So we don't want to do it. There's no benefit to us. So the question is, should you disclose it? Well, yeah, you should, but mold and mildew and musty are very much like the word mold. It's just and using the word mold is even worse. It's holding ourselves out, even though we don't mean to the client as a mold expert. We're able to detect something that even mold experts won't say when they first enter a house and smell something like that. They got to do all kinds of testing and analysis and that sort of thing. So we have to be careful. The question comes up is, well, I'm not going to write down, this house stinks or something like that. I got to come up with something better in the notes. And if you just came in, I'm going to be sending Jody at the association some seminar notes, and this is in there somewhere. I like expressions like, and you'll go with what you feel best, but I like obvious odor noted, apparent odor noted in this part of the house. That way I'm alerting the buyers to something that they should know about, because I picked up something, but I'm not using terminology that could get me in trouble in court, but I'm still getting a message across to the buyers. So any sensory perception doesn't make any difference which one at all. So on the Avid form, besides obviously the address and the date and all that, every entry we have room to room needs to be either a defect or a red flag, nothing else on that form. Now, you probably know what these words mean. I'll just do quick definitions. A defect is where, like where I'm sitting right here doing this Zoom presentation, to my left is a window. And if this was a residence and I had the Avid and it's a cracked window, that's my entire disclosure: broken window, cracked window. Nothing about the Frisbee event or the kids with the baseball, or it's a big crack. It's just a broken window, cracked window, completely done with that disclosure. Windows can break because of structural tension, structural foundation problems. So I don't want to guess what's causing it, even though there's a story to it. So that's the defect category. The other one is the red flag category, and this is not difficult. It's maybe a little more of a challenge to get it right. So look at the ceiling stain that you see there on the Zoom screen. Let's say it was a little bit, a smaller. So a lot of agents would look at that, and they have the ad, and they go, well, that's a small water stain. Well, we've got too many adjectives here. We got small, and we have water. Stains can occur from a lot of things other than water. And I don't know what's causing this, even if I have the listing, even if I have been close personal friends with the sellers for 25 years, I still don't know, not in court. I've been told a story, but I don't really know. And I don't want to extend my liability. So, you might go with something like stain noted, not big, not small, just a stain noted. A great word is discoloration. Just keep it brief. You're getting the message across to the buyer. Hey, there's something I've noticed. And if you, the buyers, this is implicitly implied, if you, kind of a redundant there, but anyway, it's implied that if you want to go back to this area and look up there, you're going to see a stain. You might have missed it the first time. What you want to do about it is up to you, not up to me. So those are the red flag things. Let me just take a quick look at the chat room. Okay, Keith's information, that's good. But leave a question in the chat room if you have one. So a couple of challenges. There's a lot of challenges. I'll just mention just two for sake of time. The first one is the ceiling fan challenge. So let's say I'm in the living room and I look around and I got my Avid and I can't find anything at all wrong. It looks great. And I have looked around adequately. So this is what I call a happy problem, if that's not self-contradictory. It's like usually when there is litigation, after the deal is closed, maybe it's a few months have passed, the agent gets a summons in the mail and they look at it and they go, oh, I remember this place. This was a disaster. So when you have adequately looked around, well, not only the entire home, but a particular room, and you really don't see anything to disclose, that's good. There's less chance of litigation. But I kind of want to demonstrate that I was really in that room. I want to say something. So I noticed there's a ceiling fan. So, oh, good, I'll mention that. Ceiling fan noted. But a ceiling fan is not a defect and it's not a red flag, so it doesn't belong on the form. So I've just introduced a new third category that doesn't belong there, and that's inventory. That's what a ceiling fan is. So now, to be consistent, I need to mention the inventory in every room of the house because I started in this room. And I don't want to do that because I've got an addendum I have to, depending on how big the house is, an addendum with a list of all the stuff they have there. And that's got nothing to do with the Avid. There's a solution to this I'll get to in a second. The other challenge, and I'm just doing two here, the spider web challenge, literally or figuratively, there's no ceiling fan. Everything looks fine, which again is good. But I want to say something to demonstrate I was here in this room. There's a tendency to compliment, like looks okay or something, but that even okay is complimentary. Compliments only belong in advertising, never in disclosure. We never say anything good. We don't have to tear a home apart, but we never say anything good about it in disclosure. There's just no need to disclose things that are okay in our perception. So what some of us do is we lower the bar because we can't find anything to say into the minutia area. And we mention, there's a scuff mark at the door by the baseboard, or the carpet's dirty or something. These are not material issues. They do not affect the value or desirability of the property. They just don't belong on that document. So now when I started the minutia stuff in this room, I need to be consistent and mention it everywhere, like I'm mentioning the inventory everywhere. And I don't want to do that. So here's a suggestion. Whenever I give you a suggestion on disclosure wording, always check with where you hang your license. There is some gray area variation, and things do differ. Not a lot, but there are differences between Southern California and Northern California, and even distinguishing the Central Valley area too, and how things are done. They're pretty consistent, but there's a couple of variations. The best terminology I've come up with or seen is nothing noted. Hey, there is a living room. Not all homes have them. This one does. I did look around. I just didn't see anything really worthy of disclosure. Great thing to disclose. So a few things on the visual inspection. Wording makes a difference. I love this. If you read down, you matter, don't give up. Or if you read across, you don't matter, give up. Big difference in the meaning of those two renditions. Okay, our sponsors. Keith is here, and I think, Keith, you're probably able to unmute yourself. Good, you can. Keith is with Old Republic Home Protection, and I do lots of events with Old Republic statewide, have for several decades. And Keith, take it away. Tell us what you do.
Well, good morning, Bob and family. Thank you very much for having me this morning. I appreciate it. So I'm sure you're going to hear a few stories from Bob today. I'd like to tell you a story, all of you, as far as in the 70s. Can any of you remember back? Oh, 70s, those were good years. So back in 1971, does anybody know what the interest rate was back then? 7.3%, right, for mortgage rate. But it started drastically climbing, right? I'm sure probably some of you have seen those. Even by 1974, it was all the way up almost close to 10%. There was a lot of inflation going on. And also what was going on with property was that there was a lot of, what Bob's bringing up is litigation, a lot of problems, especially after close of escrow, non-disclosure of things, and in particular, things that were failing, things that weren't working properly. So a group of real estate agents got together and said, there's got to be something that we can do. Of course, it was here in California, because of course, California is always the generation of creating something new and exciting, right? So we have Facebook, right? So all these fantastic things. So in the 70s, a group of real estate agents got together, and that's when home warranty was actually created. It was actually to help mitigate those problems, failures of systems and appliances that after close of escrow inevitably happen. And it's no fault of the real estate agents. It's no fault of the sellers. It's no fault of those folks. You're all good folks. And again, what Bob's doing today is making sure that, of course, we disclose, right? But at the same time, no matter how much disclosing you do, you want to make sure that that buyer's protected with another layer to help avoid mitigation and litigation, right? So to mitigate the litigation. So suffice to say, that's what Old Republic has been doing since 1974. So I'd love to be a valuable partner for you to help make sure that I keep your buyers happy. And if you're on the listing side, keep in mind we also have sellers coverage as well too. So while you're going through that listing, you can have that seller's coverage to help protect when things do fail during that listing. And then When the buyer takes over, there's less of a hassle with the transition, meaning if something does fail the very first week of the new owners taking over, we already had seller's coverage in place, which really helps mitigate that whole process of, was that already a pre-existing condition? Was that already a failure? Because more than often, if sellers have seller's coverage, then they're going to call in for a failure of a stove, a built-in microwave, excuse me, a dishwasher, water heater, those things that will tend to break down even during the listing process. So if they don't call in and it transitions to buyer's coverage and it breaks down the following week, no problem. Old Republic is there. We're going to step up and we're going to help out. And I definitely appreciate the opportunity. I put the information of our plan, our brochure, in the chat box. So click that link. You can see our current plan. And anytime that you need me, you can reach me via email or, of course, my cell phone. I'm more than happy to step up and help you. So thank you all very much for having me today. Thanks, Bob, for inviting me over today. I appreciate it. God bless all of you. And pretty soon it'll be happy 4th of July for everybody.
Yeah.
So everybody enjoy.
And you have your flag ready too. That's good for that.
I've been ready all year.
Yeah, I am too. Thank you very much, Keith.
Thank you, sir.
Okay. And that's Keith's phone number, and he's got all of that is in the chat room and so forth. So anyway, thank you very much. Another sponsor, the representative is not here, so I'll do it, and I'll do it quick. Not as good as he can. This
Actually,
is
he's here.
Oh, he is. Okay.
Yep.
Well, let me go ahead and do the talking, and then he's going to put something in the chat room. But thank you very much. I looked and I didn't see him, but I'll go ahead and do it. We had kind of prearranged that, but thank you for letting me know. Stage house, obviously unstaged on the left, staged on the right. Something, I've been doing this a long time. Something I had just no awareness of is that staged homes are now the target. A lot of them are of thieves, and it's a pretty easy crime to commit. They can see the entire house on the internet, a video of it. They can note the things that they want to actually take. Neighbors don't notice because cars are, homes for sale, vacant. Cars are coming and going. Service vehicles are coming and going, and they do it in just 10 or 15 minutes, and it's just gone. And that's where staging risk management comes in. The issue is that homeowners, two issues. Homeowners insurance does not cover this for theft of staged items. And usually the buyers are, paying for it or paying for most of it. And they somehow think that their agent's going to take care of this. And sometimes the loss can be in multiple thousands of dollars, depending on how high end the home is. So it can create some relationship issues or problems. And so that's where staging risk management comes in. You'll see I won't read everything on the flyer. You'll see the phone number at the bottom. Bob can put it into the chat room as well. And he's a wealth of information on this. If you have any questions at all, it's really been needed in our industry for a long time. Just most of us, and I'll include myself in that, we're just not aware that this is becoming a very substantial issue statewide in other parts of the country as well, and especially in the higher end homes. And with a brisk market, most homes are pretty high end today. So it's very reasonably priced. It takes away the problem of who's going to pay for what. They step in and take care of that. So look in the chat room for information, contact information on staging risk management and Bob Johnson, and also for Keith. So thank you very much to the sponsors. Next topic, and we got about a half hour, so I'll speed through this. Here's some advice. I think it's very good advice, and that is to make sure that you never complete the avid during the home inspection. Now, on the listing side, you can kind of do this anytime you want. I mean, it's in a hot market, a brisk market like it is in most of California. On the listing side, you can kind of do it anytime you want to, but in a brisk market, you kind of have to speed it along because it's not going to be out there that long. But so on the listing side, that's easy. You have access to the home pretty much all the time, I would guess, or most of the most instances. So get it done as soon as you can. It's nice to have a track record if something goes to court, that when you have a listing, you get out there and you do your avid as soon as you can. So focusing more on the buyer's side of it, you're representing the buyers. Um, Here's why we do not want to, like, let me just back him a minute here. Let's say, what's today? Today's Wednesday. Is that right? Yeah, Wednesday. So let's say after the seminar, you're representing the buyers. You have an appointment early this afternoon. And the deal comes together. So there's a contract now. That's great. You prevailed with your client. And they are really hot to trot. They call a home inspection company up and get something arranged for, let's say, Saturday. Okay. If there's any way you can get out there and do your avid this afternoon, late this afternoon, before it gets dark, of course, or Thursday or Friday, do so. It's really a good idea, an excellent idea, that the date on your avid form is going to be an earlier date than the date on the home inspection. That substantiates that you did your avid not in the presence of the home inspector. If the dates are the same, it's not good. So they have a different standard of care than we do. It's a much higher standard of care. It's much more invasive, and I mean invasive in a good way. You know, they're up in the attic if it's possible, which it usually is. Not a lot of crawl spaces in California, but if the home, maybe an older home, has one, they go under there, or have a little gadget that goes under there, and they look behind pictures and paintings. Some of them, they move carpet, throw rugs, sometimes furniture. By the way, just as a side point, if you are in the habit, especially with your buyers, of recommending that they get the home professionally inspected, a lot of agents will write down, somewhere, I recommend that my clients obtain the services of a professional home inspector. That word professional is good. Just don't use the word license. Never recommend that anybody get a licensed home inspector or home inspection. And that's because the state of California does not license home inspectors. About 32 states do. We're not one of them. Don't ask me why, long story, but professional home inspector, qualified home inspector is fine. So anyway, back to this. Let's say I'm able to get out there tomorrow. Deal comes together this afternoon, and I'm able to, work with the other agent, the buyer's agent, or I am the buyer's agent. I'm working with the listing agent. I can get out there tomorrow. So this is maybe the master bedroom, for an example. And from what I can see in this photo, there's really nothing to disclose. I'm not going to move the bed out of the way. If this was a tile floor and had like a throw rug, I'm not going to move the throw rug out of the way. And I'm not going to look behind that painting. I used to think it was a photo, but it's a painting. Let's say, so I'm not supposed to move anything. So I have nothing to disclose here. But let's say I did take that painting off the wall or moved it, and I saw something like this behind it. Well, everything about my liability position changes, especially at least in this room, and in a big way. This looks like certainly a major disclosure issue, maybe a lawsuit waiting to happen. Who knows what this might lead to? But when I'm there and I don't move things within the bounds of the standard of care of a real estate licensee, there's nothing to say. But if I, like, two birds, one stone, they say the inspection's Saturday, I got to be there anyway. I'm going to bring my buyers. I'm going to sit it out, which is good, but the buyers can do what they want. And I'll just do my avid at the same time. And that's where it's a really bad idea. That way, because I do not want to be accused of walking around doing my avid thing, and I happen to be in this room with the home inspector when he's moving that painting, and I do see it. Now, maybe it didn't happen that way, but if it's a high-end property and there's a lot of money on the line, don't be surprised if somebody in court, like a hired gun expert witness, accuses you of that. So you want to, if the dates are different, then there's no issue. So that's kind of a big deal. So to kind of summarize this part, always complete the avid prior to the home inspection. Never delay the inspection because of pending repairs, even in a slower market, which, you know, I guess eventually will happen, although it seems like it's taken a while to get here. You still want to do your visuals, just be on record of as soon as you can, either side of the deal, you'll always get it done right away, even if they have some pending repairs they're going to do. And then when you're representing the buyers and the home inspection is scheduled, if there is any way humanly possible that the buyers can attend attend the home inspection, it's a really good idea. All of the litigation in this category comes from buyers, and very few buyers who have actually attended the home inspection actually sue. So, something to be careful about. Make sure you attend. Let me just back that up. Just sit it out. Let the buyers do what they want. But you've already done your job a day or two before, or 3 days before. So, a tip. Let me quickly look at the chat room, see if there's any other questions. Oh, okay, we have the staging risk management information in there as well. So that's good. Thank you, Bob. Okay, last page of the TDS. This is really simple and it will therefore be very brief, but I do get questions about this. Here you see sections 3 and 4, depending on which side of the transaction you're on. I'll give you my opinion on how to fill this out. There's not much to say because there isn't much to write here, but in my in-person things that I've been doing for 3 decades, I often get questions about it. So my opinion, you know, do what wherever you hang your license, the broker says, but you want to check off that top box since you're using the Avid, I'm assuming. See attached AVID. That tells the buyers who might go into court and say, well, I've never bought a home before, or it's been 20 years since I bought a home, I don't know what I'm doing. Then just check off see attached AVID. That says everything I have to say about the physical condition of the property is on this form. It's not somewhere else. By the way, you know, in our room, Patricia Johnson, could you block out your screen so that it blacks out, because there's just a lot of color movement in it, and it might be a little distracting. Thanks. Then next would be, thank you. Next one is do not write anything in the 4 lines. Just leave it blank. Some agents will write down, I recommend you get a home inspection, or they start their disclosures there and finish them on another document or whatever. Just don't write anything there, because you've already said by checking off the first box that everything you have to say about your limited visual inspection is on the AVID. And of course, you've got the broker name and the date and all that. So it's really simple. Sections 3 or 4, depending on which side you're on, in my opinion, see attached AVID, sign date stuff, done with that. Nothing else other than that. That makes it really simple. Now, this is a topic that is somewhat controversial. So, you know, check with your broker owner on this, but this is the majority opinion, I know that by traveling so much around the state. Wear and tear items, should you disclose them, are usually kind of like this list. You know, there's some dirty carpet, or what do I have here, scuff marks and that sort of thing. They're really minor. They usually, if not always, fall below the threshold of a material issue. They don't affect the value or desirability of the home. All homes have wear and tear issues. If they're at least, you know, a month old, there's going to be something you're going to find like this. And they really don't rise to the level of disclosure. They are often used as filler when an agent looks around a room, has nothing to say, and rather than writing down nothing noted, they'll pick out something really, like the carpet needs to be cleaned, so they have something to say. But then they've opened up a whole new category of minutia and trivia. So usually there's no disclosure for these observations, because once you start disclosing wear and tear issues, you need to disclose all of them. So what happens is there's way too much information in the Avid. It's overwhelming. They can't, there's so many comments and addendums the buyers can't see the important disclosures that they really need to look at. Now, you may recognize, depending on your age, you might recognize this. This is a kind of a game called Where's Waldo? Waldo is a little character, a little guy that has a red and white striped shirt, and you kind of try to find him in the crowd. Now, when I do this, it's really easy to, to find Waldo. But before doing that, you might have had a hard time. So I like to say that Waldo represents the meaningful disclosure, that you really have to have in there. And all the other people represent the wear and tear stuff. And there's so much of that in the TDS sometimes, but mainly the Avid, that they really can't, they can't see this guy, and that's the guy they need to see. So anyway, something to think about. I'm going to skip down, and please, you may not want to look at the screen because you'll get dizzy, but let me go down to a category somebody had asked me about before we started. I covered this about a year ago, but that was a year ago, and you likely weren't there. Or most of you weren't there. And that is, how do you and I'm going to do a briefer version of this than last time. How do you disclose something to a buyer when the property is near a train or a freeway or an airport or a golf course or something that is going to affect, good or bad, whatever, the livability or the quality of life of that particular property? So I like to start out with this. It's kind of a funny picture in a way, but it makes a point. Let's say you have buyers that are interested in the center middle, second floor middle condo there. And hot market and all, they've been out there 3 times in the last few days. They're really hot to trot on it. And they've been out on the balcony. You've been with them. And it's really, really hard to miss the train tracks there. And maybe the train goes by, the trolley goes by, and you cannot miss it. It's still a disclosure item if they buy that home. You don't want to say, well, we saw it 3 times, we can't miss it. You still want to make a disclosure, because what you said to them on the balcony and what they say or their attorneys say you said later, if there is litigation, often are not the same thing. You want to have a record of it. But in my example, let's go with a golf course and homes that are near the golf course, fairway homes. So these would have a special disclosure, certainly that there's a golf course there. You might think, well, who can miss it? In California, makes no difference. If it's right there and you can't miss it, it's still a disclosure issue. And you've heard over the years that errant golf balls are a problem when you live right on the fairway. And you've heard from different clients that you've had that have moved in, buyers that have moved in, you maybe knock on doors there and you chat with them later and they say, we love it here. We have noticed that usually when we go out in the backyard, maybe on the weekend, we see 1 or 2 or 3 golf balls laying around, and that's because we're so close. So there is kind of like, now you have a new client. Let's say you're referred to a buyer this time. So that's great. One of your sellers who's moved in refers you to a buyer that would like a fairway home right on the green. So that's kind of like our beginning disclosure. So we just have to clean it up. We got to get, let me just back up. We got to get rid of 1 or 2. I don't want to have a conversation with them later after they move in and they're mad and they say, you told me 1 or 2 golf balls. We're getting like 9 or 10, like twice a week. So I want to warn them about this, but I don't want to be that specific. So golf balls occasionally hit the house. So that's better, but I don't really need to have the word occasionally there. Now we can go crazy on these things and never say anything, but we won't do that here. So get rid of occasionally. Golf balls hit the house. So that's better. You're just letting them know what something that happens that they kind of should know about, but maybe they don't. And but they may be hitting the nice new BMW or Mercedes in the driveway, not just the house. So we end up with golf balls hit the property. So that's a big improvement from when we started with the 2 or 3, whatever. Big improvement. Here's the problem with that, though. We're probably never going to get sued over golf balls hitting the home that they've bought. But now we can be sued over all kinds of things that can affect somebody that's that close to a golf course. So we've got to change this up. You know, they may move in and just say, hey, we love these free golf balls. It's like an Easter egg hunt every weekend. We just love it. What you never told us about, though, and we're talking to an attorney even, you know, we just retired. You knew that. And every day at like 5 o'clock in the morning, the lawnmower crew, the landscape crews start up their engines. We can't sleep and it's really lousy. Now, in real life, you might say, well, you know, there's a golf course right in front of you, but you can't say that here. So in California. And then this is a real whopper. This is a doozy in court with a big sob fest up on the stand. They say, we never thought about this, but they spray insecticide, pesticide maybe once a month. Chemical fertilizer is the same thing. Buyers can be very dramatic in court. They'll say this big cloud of toxic dust or poison floats through the neighborhood and we all get sick. Our kids get sick. We're thinking of moving out. Or at least going to have to go to a hotel when they do this for a few days. And then on a lesser note, one more, sprinklers and the wind, and they mess up our windows and all that sort of thing. So for your consideration, when there is something near the property, and by the way, near is your call. There's no number of feet or yards or miles to determine when you disclose something that may be disclosure worthy. There just is no measurement. How far away does the airport have to be? How close to the golf course? There's an elementary school down the street, but how far away? Railroads, trains, you know, there's a train 2 miles from where I live and I can hear it. I can hear the whistle blowing. It's not a disclosure issue. I kind of like it. It doesn't bother me. And so I wouldn't disclose it if I sold, but there's no, it's just your call. And that is the key to it, in my opinion, for your consideration. The key to it is tell them what's there. Do not make a list of what may bother them about what's there, because you can never make a list long enough. In disclosure, the list never ends. 2 days ago, I did a seminar for a association of realtors in a very rural part of California, mountainous hills, lots of open space. And one of the agents said, I have a buyer coming in who's lived in downtown Chicago for like 30 years, never lived in an area like this. They have a small dog and they're really excited about all the trails we have through the brush and the trees to take their little dog on a walk. But we have coyotes here and they can be a problem for a small pet. And so I'm going to make a disclosure about the coyotes. They probably have never seen a coyote. I said, well, are you going to mention anything else like scorpions? I don't know, rattlesnakes, black widow spiders, birds of prey, like in the daytime, hawks that can come down and pick up a small animal, or owls at dusk or at night? And when is the list going to be finished? And the answer is disclosure lists are never finished. They never come to an end. So you can't make a list. It will never be long enough. It's better to call them and tell them, kind of like here, what is there, not a list of what's there. Two other examples. In my travel days, I have no idea where I was here. Looks like a La Quinta Inn, but I don't know what part of California. So let's say this home's for sale. They're all in the backyard is a hotel. So that would be a disclosure issue. But I'm not going to make a list. What do you say? There's a 24-hour checkouts and check-ins, and they host a big beer barbecue bash for guests on Friday night, whatever. I'm just going to let them know there's a hotel there. So whatever happens at a hotel is in your backyard, because I won't be able to make that list long enough. And just one more. If we were all together and I asked you, what do you think is behind that wall? You'd probably say a freeway, and you'd be right. This is kind of in the Downey Norwalk part of Metro LA I-5, busy freeway. So you think, well, what am I going to disclose? Well, some agents, when I do like little workshops on this in person, they'll say, well, I'd say there's this really high wall. You know, that's bad because we got too many adjectives here. Really high, that's debatable. It stops or it lessens or mitigates the noise, but the wall isn't part of the deal. I'm not making money on it. I'm not losing money on it. It's not part of the subject property. the proximity of the freeway is meaningful. So I probably wouldn't mention the wall. It's got nothing to do with the deal, so to speak, the subject property. But what am I going to say? I'm going to say it's noisy. There's vibration, from the trucks. Runaway tires blow out on these 18 wheelers, and they're like a rocket ship going down the freeway. Oh, gasoline fumes, but diesel fumes, and it goes on and on and on and on and on. So I don't know what you do with this one. This is a really tough one. It's a real picture. I have no idea. Could you say that in advertising? Freeway close. You could say that, but anyway, more likely like this. I might go with something like property is adjacent to a freeway. And now everything that happens to you or could happen to you by living that close to a freeway is in that disclosure. Okay, I'm going to back up again here because of our time. Let me mention this here. I just have this is only one of my seminars and I don't have enough time for just that. So investor clients, you might be working with them, might be your whole book of business here. Please keep in mind that investor clients flipping properties are what you might call regular sellers. They're not like great grandfather finally died. I'm exempt from the TDS. I'm exempt, and there's no exemptions. They are a regular seller. The inherent problem from a disclosure standpoint is they usually have either never lived in the property that's for sale because they're flipping lots of properties, or they've lived there for like a week or something. So the block of information that would normally come from a seller about the condition of the home to a buyer is very valuable because there's some things you don't know unless you live in it about the home, but it's missing because the investor clients never lived in the home. So that creates a liability, and they often end up in court. And you've got these are stock photos here, but the judge is reprimanding, let's call this person Mr. Investor Client, saying, buyers just paid a lot. They just paid, $950 for this place or whatever it might be. And they've got flooring problems, roof issues, mold things going on. You didn't tell them anything about this. Why not? And then this next stock photo is very accurate. The investor client's like, I'm sorry, Your Honor, but I never lived there. And since it's probably going to be in a California courtroom, do not be surprised if the judge says, I don't care if you ever lived there or not. These people just paid about $1 million for this place. They have the right to know from the seller what the condition is. And there's a really easy way for you to take care of that, even though you've never lived in it. And here's the way. And by the way, the attorney for the investor client's nervous, their client's in trouble, and they want to point the finger to somebody else, often to you, because you've got the E&O coverage. So here in California, it's our practice, generally speaking, statewide, when we have a buyer, to recommend that they have the home professionally inspected. It's already in the fine print of the RPA and the AVID, but a lot of us, in a email, a memo or something, hey, you may want to get the home inspected. It's a good idea. But we don't do that. There is a distinction between Southern California and Northern California, and even the Central Valley. There's some variation, but usually we're not as prone to do that for a seller. But when you have a seller that has never lived in the property or has only been in there a week, this is a really good thing to be on record in writing of recommending, that you have recommended to them because they know nothing about the place, that they can, essentially pay $500 or $600, whatever it is, and provide a tremendous amount of information to the buyers, because again, they've never actually lived in it. The buyers are probably going to have their own home inspection done, but when the sellers get one on behalf of the buyers, on the TDS, in my low-tech arrow here on the left, it says additional inspection reports and disclosures. So that's what it says just there. And then they write in, see whatever home inspection company they were with. You know, I provided XYZ ABC home inspection company report number, whatever. Please see that as an additional disclosure. The buyers are probably going to get their own home inspection with a different company, and now they have twice as much information about the property, and there's much less chance they're going to be caught off guard because so many things have been disclosed, and it reduces the potential of litigation. And I will mention one other topic, and again, don't look at the screen because you will get, I'll do this one here. You'll get dizzy. And now let me maybe wrap it up with this. Let me see if there's any questions in the chat room here real quick. Let's see. Okay, let's see. Okay. I'll give you my some of these, the one about the, let me see, selling agent is representing a buyer for remote property. What should be the basis? Okay, for that one and for the one about listing agent is not a licensed professional, let me give you my email address before we end, and you can repeat it, and it'll take too long to do it now with our time frame. Listing the properties near the train, Caltrain, City of Palo Alto, grade separation plans that may affect the property. It's still in the design and plan. I would just say that there is a train near the property. That's all, or something like that. And I can fine tune that if you email me. But the update, they updated. Yeah, I know they updated it in June. And there is a box. They have the actual agent visual inspection disclosure form. I think I'm using a slide that had the last one, so I'm well aware of the changes. And it's a required box. It says and is required. A box is checked. If you're using the Avid, you want to check it off, and it's the same in the same position. I don't want to get too confusing here as the other one. It just spells out agent visual inspection disclosure form, but the Avid is still an optional form. It's not mandatory. And there are some companies, there's a large company with about 5 or 6 offices in Southern California. The owner doesn't like the Avid. They don't use it. So that's, thing, but thanks for bringing that to my attention. I was aware when I looked at it, I didn't update that particular form. But it basically says the same thing, just adds in Avid. Okay, so thank you for bringing that to my attention. Let me do this real quick. No adjectives. I think everybody knows this in disclosure. So we want to keep it short and simple. So words like small and large and fair, poor, colors, numbers, the word water like water stain, certainly mold or anything like it, we don't want to use. So, it's not unusual on a tile floor to see cracks like this. It's not unusual for agents to call them settling cracks, surface crack, cosmetic cracks, et cetera, or something that maybe not this big, but it's not unusual to see kind of, this is maybe more than hairline, but cracks like this in drywall or sheetrock, technically drywall. So we have settling cracks, we have surface cracks, we have hairline cracks, cosmetic cracks, expansive cracks. The best word to use is cracks. Just get rid of all the adjectives completely because you don't need to extend your liability by mentioning that. So taking a look at this, like 3 large settling cracks, noted near, I know this is an obvious example, noted near mold stain above fireplace. You got 3 large settling and mold, all litigious words, all kind of red flag words. We just have to get rid of those, take that, remove those words, and we end up with cracks noted above stain above fireplace. We get rid of all the stuff that can get us in trouble, and we still provide inadequate disclosure for them. So let me go down here to the end. I can always do a part 2, part 3, part whatever. Let me just mention a couple of other things. Always check disclosure suggestions that I make with company policy. And if you want to contact me, it's really easy. My name is Robert Brand. My email is disclosureinfo@AOL. Or if you want to invite me to speak at your company, I do that a lot too. There's no charge. I don't sell anything. I'm graciously sponsored by service providers so that they take care of it. I think on the AOL, I think I'm the last remaining member of AOL in the world, but I still use it. Disclosure info. If you forget my name, forget all about me. If you go to any search engine, Google, Bing, Yahoo, and type in something like California real estate disclosure training, the first